Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I'd like to talk to you about, are pets part of a will or a trust? Now, pets are part of our family. We love our pets. They're like children to us. Lord knows that my children love our King Charles Springer Spaniel and our English Bulldog. Unfortunately, in the eyes of the law, pets are property. They cannot be heirs at law, and therefore they cannot own property. As a result of that, you cannot name a pet to be a beneficiary under a will. If you only have a will, then you cannot name your pet in the will. All you can do is leave your pet to somebody else, an actual person, along with some money, and state that in the hope that they will take care of your pet. They get the cash out of the way, and they can take the pet, then turn around and put the pet in the pound if that's what they want to do. The receiving the money is not conditional upon them keeping the pet. Unfortunately, the pet goes with the money and they can do what they want with either the pet or the money. So a will is not the best option if you're really concerned about your pet. If you're truly concerned about your pet, you need to create a trust. You can name a pet to be a beneficiary of a trust, because a trust is not a court document like a will is. A trust is a contract between you and the trustee. And the trustee controls the money in the manner in which you set out. So if you name a pet to be a beneficiary under a trust, you can condition whoever receives your pet from receiving any money based upon how they care for the pet and whether they continue to care for the pet and the manner in which they care for the pet. All these conditions can be laid out in the trust. So the trust will, or the trustee will enforce the trust. So if your trust says that person A must take your beautiful King Charles Springer Spaniel and care for them properly and walk them once a day and make sure they maintain a good health and provide them with a certain type of dog food, then those things must be checked off in order for the trustee to give money to the person who's taking care of your pet. Now, of course, usually you heavily incentivize this with the amount of money you're giving them to make sure that they're meeting the standards that you set out. But a trustee can actually enforce that. Whereas a will, because it is a court document, must abide by the laws of intestacy or inheritance, which says that property can't own property. But through a trust, you're saying, person A, if you want to receive money from this trust, you must take care of my dog in a certain manner. That is completely and totally legit. So if you have any further questions about how you can make sure that your pet or pets are properly taken care for or properly taken care of should something happen to you, reach out to the Johnson Law Firm. We can walk you through the necessary process, show you how to set up a trust to benefit your pet, make sure they're taken care of, and put you at ease, make sure that Fido will be taken care of.